Good morning. The hearing board is in session. Today is Wednesday, January 25, 2017. We're meeting in the hearing room at SCAQMD headquarters in Diamond Bar. Time is 9:05 a.m. We have two matters today: Beta Offshore Case 5855-5, a petition for a regular variance, followed by SCAQMD versus Anita's Mexican Foods Corporation Case 6017-2. Beta Offshore was to have been a consent item. However, it's been taken off, so I expect it will not be a long item. So we'll call the first matter, Beta Offshore, Case 5855-5. Who's representing Beta Offshore this morning?
Ivan Tether, Mr. Camarena.
Thank you. And representing Executive Officer?
Sherry Hani Zavara on behalf of the Executive Officer.
Thank you. Those will be testifying in this matter. Please rise to be sworn in. Raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? As I said, this matter was to have been a consent item. Pursuant to Hearing Board Rule 3E2D, Senator Holden has requested that the matter be removed from the consent calendar. And so I'll turn it over to the Senator for his questions.
Thank you, Mr. Chairman and members. A question to Mr. Ivan Tether. In my opinion, here's the question. I'm going to ask you a question. I'm going to read about 4 pages that I've already typed up.
Thank you.
What is your rationale, and by what authority did you request to place this matter on consent calendar?
That would have been under the rules of the district that pertain to this, and also under the rules and procedures of the hearing board. I apologize, but I don't have those before me, but I did reference them at the time we made this request.
Are you aware that in the section addressing consent calendar, 2D and E are applicable? And I'll read it for you.
Thank you.
D states that at any time prior to submission of a case, any board member may remove the matter from the consent calendar. E, in that section, states that, this big E, states that the hearing board shall not include any matter on consent calendar if operations under the variance or order of abatement is expected to result in a violation of the Health and Safety Code, Section 41700 nuisance rule. 41705 is the only exemption to Rule 41700. Are you aware of that?
41700 is the Health and Safety Code nuisance rule. I don't believe that nuisance is alleged because the excess emissions are 2/100ths of a pound per day emitted 9 miles offshore.
But it still states that if there's any emission, you cannot be placed on the consent calendar. And the fact of the matter is that what it states, 41700, unless I stand corrected, and the only exemption from that is 41705.
Could you, I'm sorry, Senator Holden, I have the rule in front of me, and you're referencing, I think it's 3E, consent calendar?
The 3 big E.
3B, thank you. 3B is...
Right here, 3 big E.
Oh. Sorry, which is it? I know small e is consent calendar. Oh, and I see, and then under 1E. Okay. And Yes, of course. I certainly researched and recognize your right to request that a matter be taken off the consent calendar. And yes, shall not include any matter on the consent calendar if operation under the variance is expected to result in a violation of Health and Safety Code 41700. I see that. As I'd said, I responded to you with regard to the amount of excess emissions and their location.
That's what it says, sir. So,
Ms. Prusek?
May I just also respond to that? That section of our rules with regard to what can and can't be on the consent calendar does not mean if there are any excess emissions, merely only if they rise to a nuisance, as is defined under 41700, which states, except as otherwise provided in section 41705, no person shall discharge from any source whatsoever such quantities of air contaminants or other material which cause injury, detriment, nuisance, or annoyance to any considerable number of persons or to the public. And I would just, it's up to you to make that decision, but I would suggest that 0.02 pounds of VOCs 9 miles offshore does not rise to that level. And just to point out one other thing, that there is no, it's not just a consent calendar issue. No variance can issue if it is a violation of 41700. So that is not unique to consent. So just...
the only exemption it states is that for agriculture composting.
But it's not an absolute ban on either a consent calendar variance or a variance just because there are any excess emissions. They have to rise to the level of nuisance, which, as we know from other cases, is a very high standard.
Then what's the definition of a nuisance in the Health and Safety Code?
Except as otherwise provided in section 41705, no person shall discharge from any source whatsoever such quantities, not any quantity, but such quantities of air contaminants or other material which cause injury, detriment, nuisance, or annoyance to any considerable number of persons or to the public, or which endanger the comfort, repose, health, or safety of any such persons or to the public, or which cause or have a natural tendency to cause injury or damage to business or property. And in the past, when these nuisance cases have been brought, they are always brought as orders for abatement by the district, and generally our rule of thumb is notices of violations which have to arise from, I can't recall if it's 5 or more complaints that are verified by the district, generally not just the fact that there are excess emissions.
Well, anyway, beyond that point, I could take it off consent calendar anyway, which I did.
Yes, yes, you
Okay.
certainly can.
So let me remind you then that, I'm going to read a few pages here. I remind you that in the case number 5855-4 regarding 2 internal combustion engines, D87 and D91 on July 27, 2016, the petition for regular variance was placed on the consent calendar and approved. I guess that action, the action was not in compliance, but it's been argued that it was in compliance based on 41700. So I'll just continue. On November 2nd, 2016, the petition was granted an ex parte emergency variance by the chairman, not by the board, okay, as was stated in your request for affidavit of Ms. Lane. On November 9th, 2016, an interim variance was heard by the hearing board and approved with a condition. On September 29, 2016, internal combustion engine D88 failed a source test. Ms. Langen, in your declaration, page 5, paragraph 11, you stated that on the variance case 5855-4, Beta had already curtailed the rig engine D81, D82, and D83 on the platform Ellen sufficiently to offset these excess emissions on the platform Eureka. Further curtailment would adversely affect the operation of platform Eureka. So therefore, your statement is, I would think, would be misleading. The curtailment of rig engine D81 and D82 and D83 on platform Ellen was designed to offset excess emission on D87, D91. Therefore, D88 will continue excess emission during the operation. I think you clarified that, but the fact of the matter is that there's no way to offset or mitigate the excess emission on D88 because that was done for D87 and D91. Okay? You're aware of that? Okay. My next question was the catalyst element inserted and placed in D88 prior to the failure. Apparently not, because that catalyst element was inserted in D87 and D91, and the failure source test, which surprised you, took place after that insertion, after you inserted the catalyst. Were you aware of that?
What case are we talking about? What case are you talking
Is this?
Yeah, I'm
case
giving an example. Please let me continue. Because it's all interconnected. In her declaration, she refers to D87 and D91.
May I just interrupt you for 1 second? If you want a witness to answer questions, we should probably introduce the witness, and you can ask the questions as you go through and let her answer them.
Well, usually when they're making a presentation, I'm told to wait until the very end, and then you make notes and then you ask.
Right, but because you pulled it off of consent calendar, you are entitled to ask questions, but we need to introduce the witness.
Okay. The curtailment,
Let's proceed. First of all, I'm going to identify some exhibits. We have a declaration of Diana Lang, date stamp December 9th, 2016. It'll be marked as exhibit number 1. We have proposed findings and decision in this matter, date stamp December 9th, 2016. We'll mark that as exhibit number 2. Mr. Tether, would you care to introduce your witness so that Senator Holden can ask his questions?
Yes, Mr. Camarena, I'd be happy to. I'd like to introduce Diana Lang to my left. Ms. Lang, could you spell your name for the record, please?
Yes, Diana, D-I-A-N-A, Lang, L-A-N-G.
And have you taken the oath?
Yes.
And if I may, I'll just ask Ms. Lang, what is her responsibility regarding to our request, with regard to our request for the regular variance, so it establishes why she's the person to speak to these questions?
I am the Health, Safety, and Environmental Manager for Beta Offshore. I'm responsible for the environmental and air quality compliance of the oil and gas production facilities known as the Beta facility, situated on the continental shelf about 9 miles offshore Huntington Beach, California. The facility is located on the OCS lease parcels P300 and P301.
Thank you, Ms. Lang, and please go ahead with your questioning, Senator Holden.
right, Ms. Lang, in your declaration, you referred to D87 and D91.
What page are you on, Senator?
Is that correct?
Senator, what page are you on so we can follow you?
I didn't note the page when I made the notes.
Well, we need to follow you.
I believe that the reference might be to paragraph 11 on page 5.
Of Exhibit 2?
No, Exhibit 1, the declaration of Diana Lang.
Right.
And we had earlier established that the excess emissions were fairly small, and in fact equivalent to a 1/25 of an 11-ounce can of WD-40. But then we also pointed out that, and I'll shut up in just a moment, we also pointed out that there had been mitigation for the 2 engines on platform Ellen, and there was a little extra left over. But I believe, as you say, that,
Repeat that, I'm sorry, sir.
oh, there was mitigation for the excess emissions for D87 and D91 on platform Ellen.
That is correct.
And in this declaration, we mentioned that those excess emissions, or we reference that because those excess emissions were fully mitigated, and there was a little extra mitigation. So that could, in theory, be applied to the platform Eureka engine D88. That was our rationale, but you're certainly free to ask the witness about that.
Right, I can't refer to the page, but the witness will probably know that it was further stated that there's the excess emission had been exhausted from the rig for the 87 and 91, and therefore there was nothing left over for D88.
I don't think that's exactly how it went.
Then you can correct me on it.
So D88 is on platform Eureka,
I know.
and because the emission was so small and because there was additional excess emissions mitigated from the previous
As you stated, yes.
that there was enough mitigated to not require more, and because we only operate D88 only when needed, and it averages only about 20 minutes a day, that when we use it, it's because we need it. And so there's no further reduction in use because we don't use it constantly.
When you say 20 minutes a day, does that include the additional uses that you're asking for in the current regular variance over the interim?
I would say the time that we're going to use it is not additional, just the number of situations that we'll use it.
Okay, thank you.
In your statement, in your petition, it was stated that there was nothing, there's no excess. There was an excess in D88, and it could not be satisfied by transferring or augmenting that which was left over in the rig because it had already been used for D87 and D91. I think you stated that.
I didn't want to say there's no additional mitigation on Eureka that we can do. I'm saying we're not using that engine more than we absolutely have to. That's just how it is anyway. It's not used for personnel or groceries. And there's a calculated excess emissions already mitigated.
But when you have to use it, you use it. Is that correct?
That's right.
And when you use it, that it emits excess emission.
Yes, it averages 0.02 pounds. It's barely a spritz of a WD-40. It's not significant.
Well, let me just ask you a question, and if someone can answer it. If the emission 9 miles off course is not significant, why are we monitoring that situation at all?
Because
what?
there's a limit in 1110.2 that we exceeded. So we self-reported because we're required to. And we cannot continue to operate in excess of the permit or the rule without a variance.
But it's so minute, minuscule. I mean, what do we, if we the district's saying you got to comply with these conditions 9 miles off the coast, and it's not a nuisance, then I don't understand it. Maybe the district can answer that.
We take compliance seriously. We're a Title V facility. We're obligated to self-report. So we're trying to be a good business community leader, and
I've looked at the permits, so I know what the requirements are. Okay?
Ms. Broussard?
Just so we're very aware of what's happening here, the district didn't bring this case. It's not an order for abatement. This is a request for variance brought by the actual facility, who is the petitioner in the case. So as a result, the district didn't even know about the violation, but for the self-reporting. So there's no attempt to force Beta to comply. Rather, as you know, we expect every facility in the basin to comply with all rules and regulations of the district. And when they find that they are not, they need a variance or they need to stop operating. So that's why they're here. And we appreciate when companies self-report, especially when it is so minuscule, and show a willingness or a desire to comply so strictly with the rules.
It's confusing to me when we say this, we have this permit that imposes some significant restrictions and conditions on the operator, and then when you see that they're violating the permits, even though it's insignificant or not rise to a case of a nuisance, then we say that corrective action should be made or taken. And the case where this is going on, where this has happened, I don't see, well, why they needed to have a permit to operate that many miles off anyway. And if they're violating the conditions that set forth in the permit, then of course they got to be held accountable. The corrective action must be taken. The action that they are taking based on fixing the problem and getting in compliance, they're ordering Tier 4 engines, is that correct? To replace the ones that's in place. In your report, you state you're ordering 7 of them. Okay. Now my question is, what is the schedule for delivery and compliance for the 7 for each of those combustion engines?
well, I'm happy to report that probably a month from now, the first engine on platform Ellen will be in the cab of that crane, and we are crossing our fingers that everything will go well when we fire it up and use it. Then approximately a month or so later, I cannot give you an exact day, there's a lot of moving parts, the second engine will be installed. And then I'm hoping by summer, the third, which will go into D88's cab, will be installed. And then the fourth will be later this year. So we are on progress to do 4 this year and 3 next year.
But you're ordering 4 this year and 3 next year.
Yes,
What's the schedule? You have a schedule?
I sure do. Would you like one?
May I have a copy of it?
Did you already give it to him? Yes, we have a timeline.
Exhibit 10 shows the schedule for the first 2 of them.
It only our timeline only references the 3 that are subject to the 2 variances that are associated with the trains.
Because you have a target date for G88 to be installed June 30, 2017. And if your schedule is compatible with Exhibit 8A, then that's okay.
I am optimistic that we can make that. However, we might be going for a little bit more time on the regular variance just to cover unplanned, unexpected delays.
Based on your schedule, you said in this June 30th, 2017, which is not, you're not going to meet that schedule. Why, why we have to vote on that?
Excuse me, I didn't hear what you said.
Of what?
We've received a document from petitioner. It says timeline compliance. We'll mark that as Exhibit 3 for petitioner.
Oh, you have it.
He's talking about it. I'll bring him back.
This timeline compliance is for the platform Ellen and Eureka, the one I just received, and it's for phase 1, phase 2. What engines are we're talking about? For both of them?
I'm sorry, I didn't hear
Explain
you.
this schedule to me, please.
Sure. So the reason there's sections that are gray, I had provided Maria with a timeline, and all I did was insert some new information. So my original estimate is somewhat grayed out, and I prefaced the beginning with original estimate. So phase 1 and phase 2 are basically behind us. In the updated estimate section where it says November 21st, that's when we ordered the Eureka West crane. We were obligated to order it within 7 days of receiving our permit for the cranes, which was received on the 16th of November. It took 5 days to get to us. When we got it, it was Thanksgiving week, so we got the permit, we picked up the phone, and we ordered our Eureka West crane, but we also ordered a center crane, so we actually ordered 2 that day. And then I kind of go into December 1st. It talks about Cummins, that's the crane engine manufacturer. It was recognized that the torque converter, which is not part of the crane engine, has to be reconfigured or rebuilt because the new crane engines idle at a much higher speed. So it's not a in-kind replacement for the torque converter to go from the old engine to the new engine. So that contributed to some delay, which is why we're installing in February instead of January. That was my original estimate. The next section from January 12th describes a lot of detail that was from notes that an engineering group and the crane operators went and visited the crane engines where they were at in California. I'm not sure exactly where, but I didn't go on that field trip. But they described all the different things that are going on before they can be shipped to be painted. But they're at the paint shop this week. So we're 1 week ahead of time on our schedule that was predicted on this in the first part of January. So we're at where it says on the second page, update ahead of schedule by 1 week. The first engine is getting painted. Then it'll get shipped out next week to our onshore facility where we have to secure it so that we can safely transport it offshore. You don't want to wrap a chain around it and have the guys pick it up because it might damage. So it needs to be packaged securely, put in a bin, it'll get shipped offshore, and then they estimate approximately 2 weeks to do the install. That's with the company called Nixon Egley, if you see that word combination. Okay, so that brings me to end of February, which is the first engine. The second engine is close behind. However, we're not going to do it concurrently. We're not installing both at the same time because we want to get the first one operating. But as long as everything goes well, the second one is going to be quickly following. And all those changes to the torque converter can happen quickly once they get it optimized on the first one.
This is referring to D87, D91 on platform Ellen, is that correct?
Yes.
And what about platform Eureka for D88?
So the third engine is in production. It's being built in Chicago. And we expect delivery, let's see. Well, we expect delivery, I think, or installation in midsummer. So I'm guessing it'll come in May and go through the California upgrades and then paint and then delivery.
Now, you're ordering 7 of them.
Yes, we've issued purchase orders for 4.
What about the other 3?
That will be next year under a different AFE, Authority for Expenditure.
How many platforms out there in that you're operating?
3.
3 of them. What are they?
Ellen, Ellie, and Eureka.
I'm sorry, repeat that.
Ellen,
Yes.
Ellie,
Okay.
and Eureka.
How many engines are on Ellen?
2.
2. And are on Eureka?
3, and 3 on Ellie. Wait. 3, 6, 7, 8. No. 2 on Ellie, 2 on Ellen, and 3 on Eureka.
So that's 7.
Ms. Brusay.
Fine question. You're upgrading 7 of them, but only 3 are currently not in compliance, is that correct? The 2
Yes.
on Ellen that is a subject of the previous variance, and the one on Eureka D88, which is the subject of this variance, is that correct?
Yes.
So the other ones are just being upgraded, but they're not in non-compliance.
Correct.
Thank you.
So on Eureka is D88, and there's another. What's the number on that one? There's 2.
What's the numbers on the other cranes on Eureka?
Yeah, D88 on Eureka, and the other one is
The cranes are D87 to 93.
right.
So they're 2 of those numbers. Mylan's looking it up. I'm sorry, you don't have them.
That's how we
They're
keep
not in
track
like
of
an
them. We
order
have to
that
keep
makes
track
sense.
of them.
We only need to keep track of the ones that are the subject of variances.
I understand, but they're also,
Okay, 88, 89, and 90 are on Eureka.
and those are the ones you're ordering for them as well eventually?
I'm not sure where the 4th engine is going to go in. That's not currently my choice, so I'm leaving it up to the engineering group.
My concern, yes, is D88, that's the matter before us. Then 87 and 91, which you commingle in your petition for, as you request a variance for D88. And you also talk about your maintenance program. One, that you, every year, once a year, you provide maintenance for this, for the engines, and you change the oil, you do an overhaul, you change the oil every 250 hours, and it should be operational. But you discovered over the years, since 2012, that you've had problems with those engines, those engines, since 2012. Since 2012, you had 5 different case numbers, because that means you've had some problems and you voluntarily come in to ask for variances. I think you've had like 9 ex partes, and you had 5 different case numbers. So you've had a history of having some problems with. It's important for me to know.
No, I'm just saying if there were 9 cases, it wouldn't be at 5.
Pardon?
So if there had been 9 cases, we wouldn't be at
They had 5 cases
5 cases.
and 9 ex partes.
Ex parte would be,
Yeah,
that
yeah.
would be a case.
It says right here in that record. This one here, that's what it says.
Are they all related to cranes?
So you've shown a history. I'm just trying to find out whether or not we are doing what you're supposed to do in terms of maintaining the equipment, where you don't have regular breakdowns and failures, and that you are notifying us in a timely fashion that you do not anticipate is going to fail, but you have a history of failures, okay, where you had to ask for some reconsideration. So that's the question is, you are maintaining these engines on a regular basis.
Yes.
And what is your method for maintaining them and keeping them in operating condition?
Well, much of what you said, we do quarterly inspections. We actually do daily before use. A lot of the inspection has to do with, will the crane perform the lift safely? We do the oil changes every 250 hours. We do annual tune-ups. These are old original engines, which is why we're doing the replacement. And this crane had never failed before, but it also doesn't have the catalyst. So while we didn't expect it to fail, we didn't have a catalyst that could be changed or cleaned because this crane had never failed before.
What was the cause of failure, do you know?
I'm guessing it's like an old car. I mean, it's 195 horsepower. It's smaller than your average. I mean, it's like a 4-cylinder car engine from the 70s. It's an old.
By inserting a catalyst, you think it would not have failed?
I think it would have helped. However, the time to permit and the time to install the new engine it'll be quicker to install a new engine than to permit and install catalyst.
I keep referring to D87 and D91 because it's part of your petition for D88, because in D87 and D91, you did in fact install the catalyst.
Yes, and the catalyst manufacturer, I know we're going back to the case that's not before us, but that catalyst manufacturer had assured us that while they couldn't give us the one that we asked for, it was a part number, I don't know, like 17388, they had one that was an identical or better insert that we took their word for, and it turned out to not be better. So we didn't expect that source test to fail because we had brand new catalyst installed. So.
Yeah, in your petition for D88, you did specify the fact that it did fail after inserting the catalyst in the D87, D91. It failed.
Right, because that catalyst.
The source test, right.
Yeah.
But I didn't know that you had the wrong part in there. You didn't indicate you had the wrong part.
We did.
You did have the wrong part?
I don't want to say it was the wrong part. It was presumed to be identical.
But not, obviously.
But it didn't test identical, right?
Thank you, Mr. Chairman.
You have no other questions? Board members have any questions of the witness? Does the district have any questions of the witness?
No, Mr. Chairman, thank you.
Mr. Tether, you wish to present any other witness?
No, Mr. Chairman, that's very good, and thank you, Senator Holden, for your questions.
District have any witnesses?
The district doesn't plan to have any affirmative witnesses, but I have air quality engineer Maria Vabal here in case the board has any additional follow-up questions.
Board have any questions? Thank you. Senator, you have some questions?
Yes, what's your name, ma'am, the air quality engineer?
If you have some questions, we're going to have the
Right.
attorney introduce her.
Can you please state and spell your name for the record?
Yes, my name is Maria Vibal. That's Maria. Last name is spelled V as in Victor, I B as in boy, A-L.
And did you take the oath this morning?
Yes, I did.
And can you please state for the record your position here at the district? Your position here at the district?
I'm a permitting engineer. I'm an air quality engineer with a permitting and engineering group.
If the senator has any questions.
Right, the Beta Offshore personnel was to notify you in advance and let you know when they're going to have a source test. Did you ever get that notification, 24 hours?
They actually notify me and the inspector. They send us notifications.
Or they supposed to keep a record of all the daily records?
Yes, they do.
Did you receive those daily records?
I do not because that is not required in permitting.
Isn't that what?
It's not required in permitting, but I believe that the inspector who's with the compliance and enforcement unit, they are provided that information.
Do you have any reason to believe that that information is not available or is available?
I believe they are available because every time the inspector requests that information from them, Beta staff responds in a timely manner. So the records are always available.
But to your knowledge, the inspector from the district has ever visited these platforms?
Yes, they have. They do regular inspections, and also they do inspections if there are breakdowns or if there are complaints or any other instances.
They maintain a record of the breakdowns or the fact they visit the platform, or do you know that to be a case?
As far as I know, they do maintain.
Have you seen these records at all?
In the course of my conversation with them, especially if I'm doing the permits, I talk about compliance issues with the inspectors, and they have that information.
With these requirements that's stipulated or provided in the permits, rather stringent, why is it necessary to meet those stringent requirements when they're 9 miles offshore?
I'm not sure that Maria can speak to why we have particular rules or why we follow them.
Is that your question?
Yeah, I just asked a question.
Why we have the rules? Why the district adopted the rules? Is that the question?
No, that was not the question.
What is the question?
The question is, these are stringent requirements. Are they being met?
Which
That is in the permit. Stringent requirements in the permits, are they being met, yes or no?
are we talking about this particular engine or?
All of the engines that you inspect.
Okay, as far as compliance issues, I believe the compliance inspector will be in a better position to answer that.
So our compliance inspectors are at a mandatory training this morning, and they won't be in for most of the day. So unfortunately, we can't speak to that issue right now.
Ms. Prusak.
I just was going to remind the senator that Ms. Vibal I just was going to remind you that this witness she's a permitting engineer, not an inspector, so she could not speak to inspections and compliance, rather only to questions having to do with the permit, for example. I would assume she could answer questions about the timing or potential timing of any pending applications or things of that nature.
Well, she's permits, right?
Correct.
Right. And so therefore, one is not isolated from the other. If the inspector is inspecting, then they're inspecting based on the criteria set forth in the permit. And I'm sure, I would hope that they would have some dialogue regarding whether or not the emission exceeded that amount in the permit, because if you get a variance from it, that's why you're here, saying we didn't meet the conditions set forth in the permit. They're not strangers talking from one to the other. Anyway,
Does not have
I understand that what you're saying.
firsthand knowledge of the inspections, and so cannot serve as a witness of evidence for those types of questions.
And the inspector is not around today. All right, thank you very much.
Anyone else have any questions for Ms. Vibal? Mr. Tether?
No, Mr. Cameron, I do not have any questions. Thank you.
Ms. Lang?
Just to bring this back a little bit for me. Okay. Just for confirmation, I know that you signed your declaration, but just for confirmation, I just want to go through information. in the findings and decisions, which is Exhibit 2. And the change, well, first of all, since the last variance was issued, the interim variance, your statements are that you have followed the conditions. Is that correct?
Yes.
Okay. And that there is only really one thing. I see condition 1. Can you speak to what it is that you're changing from the previous variance?
Yes. Where?
It begins on page 3, I believe, of your, of Exhibit 2.
Yeah, this is
Yeah,
the
okay.
findings and decision. So I think it's,
Sorry, let me just find my spot. I know that we wanted to add approximately 3 additional reasons to use that crane. That was upon further discussion with what exactly do we use that crane for.
And that's what's found.
Sorry. I wanted to add to that. I'm looking for where my discussion
this is
was.
a restatement of what we wanted from the,
Well, we wanted to add 3 reasons for using the crane. Okay, the requested amendment would allow, in condition 1, the west crane to be used for the following additional tasks. To,
You're referring to a document. Would you tell us which document you're referring to?
it's in my declaration, but I'm not,
Exhibit 1,
Exhibit 1,
page.
Exhibit,
here, we'll find it.
Page 3, is it? Is that what you're referring to? Number 4.
I didn't have a copy of that. Okay,
End of the night.
so page 5 of the declaration, in the first
Okay.
paragraph. So the 3 additional reasons that we want to be able to use the crane is to access the exhaust system for the 3 rig engines that are on platform Eureka.
Okay.
If anything would need to be accessed, it would have to be from that crane. To move tubing, pipe, or waste bins on and off the platform, because the real estate where those bins sit is the reach for that crane. And to move scaffolding as needed on the west side of the platform.
Okay.
There's scaffolding for various things. The distance between the decks is quite large, so they erect scaffolding under the decks to get to piping that's needs to be accessed.
Okay. And those are the 3 things that you determined since the last variance that were needed.
Yep.
So you just incorporated them
Yes,
into
please.
this,
Yeah,
correct?
in addition to the other 2.
In addition to the others. Okay. Just wanted to confirm that. Thank you.
Ms. Prusak?
And just to confirm, that condition is not meant to limit the uses that you currently have for that crane. Is that correct? It's merely to state for the record what are the uses of that crane and that you will not go beyond that. But it's not meant for any kind of curtailment or minimization of the use of the crane. Is that correct?
That's correct.
Okay, thank you for that clarification.
Any further questions for the witness?
Right. On the last page of your petition, you show a diagram, platform Eureka. And it shows the west crane, center crane, and east crane. I think you can easily explain its usage by referring to the platform in this photograph. And you were saying that the east crane does what? What's its function, and the west crane?
So I don't think I identified all the uses for the east crane, but if it's not the west crane, then it could possibly affect bringing personnel or groceries and supplies for the personnel on board.
In the center crane?
Well, they have different reaches, so I didn't come, I'm sorry, with all the list of all the things that they do. they're going to all be used for the movement of equipment or chemicals that are associated with corrosion inhibition, scale, prevention, for reaching scaffolding in the center or reaching scaffolding on the east.
The west crane is the one that failed, D88.
Correct.
And center crane, what is that number? D what?
Just a minute. It's either 89 or 90.
East crane is D89. Center crane is D90.
Thanks.
Okay, and that function is what?
To provide lifts for the associated areas that they can reach on the platform. So it's going to have to do with either well work or well maintenance or personnel, equipment. You know, it's pretty much, we're in the oil and gas business, so it has to do with everything that is necessary to safely produce oil and gas.
Okay, thank you.
Mr. Tether, yeah, I don't see in the proposed findings a date by which the hearing board's jurisdiction ends.
Can't be longer than a year, right, from the emergency.
We put in September 15th.
7?
I'm fine with that.
I'm in the wrong notebook.
Yeah, okay.
Did we volunteer earlier? That's safe, I think. We,
Okay.
based on our based on the new timeline and Ms. Lang's testimony, we can move that up to September 15th and be assured that we can complete everything well before then. But there's no need to wait until Halloween. I'm just saying that we had, in the declaration and the proposed findings and decision, we had suggested a final compliance date of October 31, 2017, and we can move that up to September 15, 2017, a month and a half earlier.
Exhibit A,
What exhibit?
it says A as an alpha.
Okay.
It talks about I'm sorry, is not replaced by June 30th, 2017. Now, you're going to slip that date, is that what you plan to do?
I believe the June 30 date was a date imposed for us to present a report if we had not achieved compliance by that date. And at that point, we would state exactly what the situation is. I don't recall, frankly, if Ms. Lang said that there is a possibility of getting the engine D88 replaced with a Tier 4 engine by that time, but that was a time that we needed to report to you.
It's written here that it suggests to me that your target date would be June 30th, 2017, and if you didn't meet that date, then you would have periodic reporting periods.
Yes.
We'd submit a progress report to Maria, the witness for the district today, and also to Rafael Reynoso.
But what did you have in mind when you put down June 30th, 2017? That it would be in compliance by that date? Yes or no?
No, I think we thought that it would take more time into the summer for compliance, but that we could give an updated report by June 30th.
Doesn't say that, but
I believe this condition was recommended by the district. simply wanting to know what was going on at that point in the timeline.
All right.
Thank you.
Okay. No other questions for Ms. Vibal? Is there any member of the public who wishes to testify in this matter? I see none. Mr. Tether, you may make a closing statement.
Thank you. We had requested, and I believe you've already done this, that the testimony from the November 9th, 2016 interim variance hearing, as well as the sworn declaration of Diana Lang and the proposed findings and decision submitted to the hearing board on, I believe, December 9, 2016, be incorporated into the record of this case. We've all been over the facts as asserted and examined that Beta's West Crane engine D88 failed its source test for VOCs on, according to results received early on October 31st, 2016, that the failure was unexpected because of regular maintenance, real-time monitoring by crane operators, as well as prior favorable source tests. I believe in 2013, the source test of engine D88 was produced emissions of about half what was required for compliance. That continued operation of the West Crane is important for maintenance operations and other operations, but that the maintenance operations help ensure effective and safe operation of the platform equipment, which also maintains compliance with permit conditions E2 and E8. The excess emissions are 2/100ths of a pound per day. And we have requested that the variance condition number 1 from the interim variance be modified to include the 3 additional usages which were presented by Ms. Lang. We've received the permits and ordered the engine according to the required schedule in the condition in the interim variance, and we respectfully request a regular variance for the period until September 15, 2017, to provide time to receive, install, and commission the Tier 4 engine that will replace the current engine D88. Thank you.
Thank you. Closing.
Thank you, Mr. Chairman. Just to reiterate that subject to the proposed conditions that have been submitted as part of the findings and decision that you have before you, the district does not oppose the granting of a regular variance.
Thank you. Discussion, board members. Ms. Byrd.
I believe that we can make the findings. From the documents that have been presented and requested to be placed on consent, I believe that that time that I could make the findings, and I believe today that I can make the findings. We made the findings for the interim variance, and things have not really changed. There's just a request for one condition for one of the uses of the crane itself that was determined since the interim variance was issued. And I believe that the documents that have been marked with the declaration, even Diana Lang is here today, but she confirmed earlier that everything in the declaration she still agreed to, as well as the conditions that since the interim variance were being carried out, things that have timelines, some of which had to be moved based on not receiving equipment in a timely manner, but other things have been confirmed that have taken place. The permit applied for, received, engine ordered. And I believe that the Exhibit 2 spells out the manner in which the findings can be met, as were spelled out in the interim variance as well. The findings were met. And with that minor change with the understanding in Condition 1, I believe that I can make all the findings.
I'll second the motion. Discussion on the motion?
You didn't make a motion.
Yeah, did you?
Oh, I'm sorry. I was getting ahead of myself. Anybody else on the findings? Okay,
Okay.
now you can do it.
Now I'll make a motion. In the matter of Beta Offshore, located at 111 West Ocean Boulevard, well, that's the address for the office, obviously. It's Beta Offshore. This particular facility address is OCS lease parcel P300/P301 on the outer continental shelf, platform Eureka. I move that we issue this regular variance for the equipment for the equipment included in the petition, which is D88 internal combustion engine. And it is for I'm sorry. I'm looking for the conditions. Okay. For the permit conditions and district rules that are outlined on page 4 of the petition, some of which we crossed through the last time, and I guess I should maybe go through and state which ones we're still referring to. We're still referring to Rule 1110.2, D1B, Rule 203B, Rule 2004 F1, permit condition section E2, permit condition section E7, permit condition section E8, permit condition section K8, and that is with expected excess emissions of 0.02 pounds per day of VOCs. This is for the period commencing today and going through September 15th, correct? 2017. And I think that's all. That completes my motion.
Okay, now I'll second it. Discussion. Ms. Broussard?
I'm sorry, did you say you were incorporating the findings and decision?
Incorporating finding the decisions from the interim variance with the one change of the addition to the uses in Condition 1 that were stated and mentioned in the declaration from Ms. Diana Lang, which is Exhibit 1.
And also the date of September 15th, 2017, as opposed to October 31st?
Yes.
And finally, obviously reflecting the change in hearing date and the fact that the parties are here and represented.
Yes.
And not on consent.
Not on consent, but represented. Yes.
Thank you.
On page 8, I don't recall if you inserted a date. Findings and decision.
Exhibit 2, page
Yes.
8. I did not insert it, but it will be
February 9.
February 9. Applicable fees. Thank you.
Okay, there's essentially no change except for the dates.
And operation,
Sir?
you mentioned that for one usage of the crane.
Yeah. And for how the crane is to be used, but there's no request, there was no indication that there would be any change in the excess emissions, nor the amount of time that the crane will be used. These emissions are exceedingly small. 9 miles offshore. No way there's a chance for any public nuisance to occur. I said there's no chance, no opportunity, very little opportunity for any public nuisance to occur, given the amount of excess emissions and the fact that it is 9 miles offshore.
Mr. Chairman, I noted that with regard to payment of applicable fees in paragraph 6 of the proposed findings and decision, I inadvertently put in 2016, and it should be 2017. So I understand it's February 9th, 2017. Thank you.
Ms. Byrd?
Yes, we'll make that change. That's on page 8 in Exhibit 2,
I
number
agree.
6.
I accept that change. Further discussion on the motion? Dr. Lerner, how do you vote? Ms. Prusak?
Yes.
Senator?
On the fee specified in this section?
Yes.
What is the fee?
Well, there's a, if you'll read on page 8, the excess emission fees are reduced by 50%.
Do you have a separate motion on that?
We normally make a separate motion. In this event, that was included in the body of Exhibit 2, which is the findings and decision.
In order to get my vote, I would have a separate motion.
Okay, so you're voting no?
Unless you separate the question.
Okay, I've got 4 votes in favor of the motion. You vote yes or no?
I'll vote yes on the variance.
No,
Separate the question on the finances. Is that possible?
the motion that is before us is to adopt the findings and decision in Exhibit 2. Yes, we normally make a separate motion on the excess emission fees if they are to be adjusted. In this case, the parties agreed to the proposed excess emission fees in Exhibit 2, and the motion is for what is in Exhibit 2. Ms. Prusak?
I just wanted to refresh my memory. Did we have a separate motion on the interim
Yes, we did.
variance? Okay, so that motion has already been made, and I would not be inclined to
Fine.
I would not be inclined to rule any differently. So I don't know if perhaps other board members would want to state whether they would be inclined, in which case, if the answer is no, then we don't have to revisit it.
Doctor?
I think this was discussed in detail at the very last moment of the discussion that afternoon. And I think we all agreed that the reduction in fees by 50% was okay. So I'm inclined to just let this whole package go through and not revisit this as a separate motion. So I would be in favor of just, my vote yes still stands.
Ms. Prusak?
As does mine.
My comment is that the district overhead requires that the fee shall be what it shall be. You have to have lawyers, you have inspectors, you have program writers, and so on. And when there's a violation that's been determined as a violation, I personally, in retrospect, would have reconsidered, see no reason why an exemption, a dispensation from the regular fee should be granted. The board set the fee, and the fee is what it is. And on that basis, if the question is not separated at this point in time, I will cast a no vote. Not that I'm against what you're planning to do at those platforms. In fact, I support what you're doing. But I think the district has too much overhead. When the district was set up, it was decided the district should determine how it would be funded to finance its support and support the personnel, to do the inspection, et cetera, et cetera. And if we continue to give dispensation from what the fees are, it doesn't help the district in terms of meeting its budget obligation. And so, for that reason, I'm voting no, and henceforth, and all future requests for dispensation from the fee will be a no vote as well.
You've made the argument that I make almost every time a request for adjustment of fees comes up. However, the district rules and regulations do provide for an adjustment at the discretion of this board for certain things like hardship and if the matter is inequitable. And as Dr. Lerner indicated, we did discuss this at length at the last, at the interim variance hearing. So that's what it is. Ms. Prusak?
I would just echo both of those comments. Number one, that that exact point has been raised before and is a very good point. And also to echo the fact that we actually are under Rule 303M of the district granted the discretionary power to adjust any way we see equitable the fees when it's unreasonable hardship or otherwise inequitable. And I know this was argued, and the board had found this finding to be satisfied here, given how far offshore it is and how minimal the emissions are as compared to the minimum they would have to pay each day, and that would be inequitable. I think that was the findings that we had made.
Okay.
So on that point, Mr. Chairman, hardship, barrels of oil every day, there's no hardship on these people.
I don't think we based that on hardship. It was inequitable.
So, well, I was just saying there's no hardship there. Anyway, if you don't separate the question, not that I'm against what you're doing to correct the problem, I'll have a no vote.
Okay. Motion passes 4-1. The board will take a recess and reconvene at 25 minutes to 11.
Thank you. Well, this is yours, Sherry. Thank you for handing it to me just at the right time. Let's see here. All right.
Faced with that. I don't remember if this was around Thanksgiving or whatever, but listen.
We should dump the cups.
I know. Being generosity of spirit. And it is,
Because they had done it before with the DA.
Maria, thank you.
They had done that before, which you stated, so we went along with them. But
We're back on the record. The next matter is SCAQMD versus Anita's Mexican Foods Corporation, case 6017-2. Who's representing the district executive officer?
Good morning, Mr. Chair, board members. Bay Gilchrist on behalf of the executive officer.
Thank you. And representing the respondent, Anita's Mexican Food?
Good morning, board members. Olivier Thayard of Shepherd Mullen for Anita's.
Thank you. Those who will be testifying, please rise to be sworn in. Raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? I do. Thank you. You may be seated. Opening, Mr. Bakerst. Gilchrist. Got it right. I'll get it right eventually.
It's okay, Mr. Chair. My first name's hard enough to pronounce, so when you combine the two, it gets a little tricky. So we're here today for a modification for an order for abatement that was previously entered approximately a year and a half ago. The district has witnesses available to answer questions if the board members have questions. The parties have reached a stipulation regarding the proposed findings and decision, which we'll request be marked as exhibit number 1. And with that, I'll just say that we have witnesses available if the board has questions regarding the proposed stipulation of the findings and decision. Thank you.
Mr. Thayard?
Yes, briefly, board members, I just wanted to give a brief recap of where we are, and otherwise I agree with Mr. Gilchrist as to the present procedural posture. So Anita's Mexican Foods is a company based in San Bernardino. It's a family-run, minority-owned business employing a largely minority workforce of unskilled and some skilled labor as well, approximately 270 employees in San Bernardino. It's a business that manufactures tortilla chips and other snack foods that you might see in your grocery aisle. For instance, if you go to Trader Joe's, as I may have mentioned before, and buy a bag of Trader Joe's chips with the Trader Joe's brand on it, they would actually have been made by Anita's. And as Member Byrd pointed out, I do have some of the chips, which you see, they don't have Anita's on them, but they do have brands from other companies. Anita's is seeking to extend the order for abatement related to line number 4. It's the most important line for Anita's. It's critical to the business's existence, representing about $18.5 million in revenue, and many jobs are directly related to the operation of line number 4. At the last hearing, you saw the hundreds of people that depend on Anita's to take care of their families. Didn't bring all those people today, but there are a couple that wanted to come and are sitting behind us. So, as Mr. Gilchrist mentioned, Anita's is seeking to extend the order for abatement until such time as AQMD amends its rules to account for Anita's unique situation. Anita's cannot at this time obtain a permit for line number 4 because they are not able to achieve the 30 parts per million NOx that is required by the rules. So the parties entered into this stipulated order to allow the line to operate under certain conditions. 3 very brief updates since the last update that we submitted. First, we're requesting an extension until October 31, 2017. That is reflected in the papers that you saw. That was discussion with the district. The rule is currently scheduled to be amended according to the written rule schedule May, but I understand that might slip to June, and sometimes the governing board does, takes it out even further. So we figured let's give a couple of extra months for time that we can't control. And also, even though the permit application for line number 4 is in, there might be a little bit of administrative time even after the rule is amended to actually issue the permit. So we felt that October 31 was a reasonable date to ask for the extension upon consultation with the district. Second, in response to Ms. Prusak's question with regard to technology available to meet 30 ppm. We did, Anita's retained a consultant who is here prepared to testify or to answer questions with regard to the survey that they performed, which I understand conforms with the district's own analysis that it is not possible to meet the 30 ppm as currently written. We did provide a copy of that survey, and we would like to move that into evidence at the appropriate time, which I think would be Respondents B. And then finally, as Mr. Gilchrist mentioned, we did work in good faith with the district to stipulate to certain facts that are in the findings and decision. And to assist the district, we provided both a clean version of the conditions and also a red line so you can see the relatively minor changes from the existing order that's in place, and so you can clearly see the changes that have been made today. I do have two witnesses available to testify today, Mr. Alec Gomez, the Assistant Plant Manager, and Mr. John Furlong at York, who knows more about the rules. I'm happy to make them available to answer any questions from the board, since we did stipulate to the facts. If for any reason the board does want direct testimony, we're prepared to do that, but otherwise we'd prefer, in the interest of all of your valuable time, to just make them available for questions. So in conclusion, we respectfully request an extension of the order for abatement on the stipulated conditions until October 31st, 2017. Thank you.
Thank you. First, let's mark the exhibits. Previously, last year, I think it was in May, we had a document, the declaration of Mr. Frank Koser, which we marked at that time as Exhibit A. And so the report from York Engineering submitted by Mr. Thaird will be marked as Exhibit B. The proposed findings will be marked as Exhibit 1 for petitioner, and the joint status report, which is date stamped December 14th, 2016, will be Exhibit number 2. Board members, any of you desire a witness from either party? Ms. Prusek.
I just had a few questions, some of which may have been answered in previous hearings, but I would just like to confirm or be reminded or refreshed of the answer to some of these questions. And I think we could start with someone from Anita's would be fine.
Okay. I think Mr. Gomez would be the appropriate person to answer your questions.
Would you introduce him, please?
Yes. Mr. Gomez, can you please state and spell your name for the record?
Alec Gomez. Alec Gomez, A-L-E-C-G-O-M-E-Z.
And what is your title and position at Anita's?
Assistant Plant Manager.
And in general, what are your job responsibilities?
Oversee production, primarily focusing on production and maintenance.
Thank you.
Mr. Gomez, you took the oath when I administered it?
Yes.
Thank you. Ms. Prusek.
I only had just a few questions. The first one is, can you remind us, is Anita's the only manufacturer of the types of products like chips or crackers that require this higher temperature in the district?
There's other competitors that we have, but as far as the West Coast is concerned, we're the only manufacturer that currently do these customers, but there are competitors.
Are they under the purview of the South Coast Air Quality Management District?
I believe so.
And do you know if they're currently in compliance with?
I do not know.
Okay, maybe I would ask the district at the appropriate time.
And at the appropriate time, perhaps I can shed some light on that.
You could do that right now, I would assume.
Anita's, to refresh everyone's recollection, was in a unique situation because there was, when 1153.1 was written, it did account for many of Anita's competitors by creating an in-use date that allowed many of the competitors, now, I can't speak from personal knowledge, I'm not a witness, and I don't know what some of their competitors did for sure, but my understanding is that that in-use date was helpful for many of the competitors, but unfortunately did not go back far enough to cover Anita's, so they found themselves in a hole.
And that's because Anita's equipment for line 4 is newer, is that correct?
Yes.
Okay.
Correct.
And I'm just wondering, was Anita's, was the company vocal during the rulemaking, or did you participate in the rulemaking in the first place and voice concerns at that time?
During that process, I wasn't actually involved with the company. I've only been with them for 2 years, so I do not know.
Okay. It's not essential. I just wanted to have some background because it's not a variance. And the final question I had, and I asked the questions especially because if we were to approve the modification today, we would have a very long-standing order for abatement, and I like to see motion towards compliance, obviously. The draft, is there a draft rule currently or a draft amendment that is before the district?
There is, and that I don't think Mr. Gomez follows the rules directly, but Mr. York is familiar with the draft rule. There is a draft rule for 1147 that is circulating that right now does exempt food ovens. So if it passes, Anita's going to be good
That
in
is the
terms of the
question.
rule.
That is the question. I want to make sure on the record that if we're awaiting the anticipated rule amendment, that it will take care of the issue for Anita's. And if whoever the the witnesses that can confirm that.
I would love to actually hear that from the district, but my understanding is that if the rule passes as it's currently drafted, which we read before coming into this hearing, then yes, Anita's would be able to get a permit, and based on my discussions with Mr. Gilchrist, there is no expected reason at that point why line number 4 could not get a permit, and we would need this order hopefully before the end of October. That would happen.
Okay, and perhaps if I can ask the indulgence of my fellow board members, unless you have any questions for.
I do have one question.
Okay, then I'll hold it, but I'd like the district to weigh in on that.
Mr. Gomez, when did line 4 go into operation?
It was about, I think we're about a year and a half, 2 years ago now, isn't it? I can't remember the exact date.
So about mid-2015, approximately?
No, I think it was a little bit later than, I don't have the exact date on the top of my memory.
It's been more than a year.
Yes.
Thank you. Anyone else have any questions? Ms. Bird?
And Mr. Gomez, I'm not sure if you know this answer, but, and I can't find it in my notes, but my recollection was that this equipment was purchased, but perhaps not in use, and that's how it got.
It was just delayed as far as schedule for delivery, so if it would have actually hit the delivery deadline, we wouldn't be in this situation.
Okay, that was my question. Thank you.
Senator?
Mr. Gomez, do I understand you saying that you have equipment on order that if once it's in place, you will be in compliance where you can use line 4?
No, that's already existing equipment.
Existing equipment that's in use,
Yes.
and you're still not in compliance?
As far as the rules currently, from what I understand of the rule, we're not able to actually hit the 30 parts per million NOx emissions
I
with a
understand.
food oven. So once the rules are modified, then we would be able to be in compliance.
Yeah, I think the question was asked to you earlier, like competitors, are they providing the same type of product, and yet they're in compliance with the, we'll pull the mic up so you can answer.
No, we'll stay with Mr. Gomez.
Okay.
If I can, I believe the question that Ms. Bird was asking was a back-in-time question. I think what she was asking was, back in 2015, when you ordered the equipment, and then it was, because the line is in use, but there was an in-use date of, I think, November 2015. It had been ordered so that it would be scheduled to be online by then, but it did not come online by then. It came online after, so they were not able to get that exemption with the rule. I think what she was asking was a go back in time question. So I think you're asking a current question. So I think that's partly why he's having trouble answering the question.
So in other words, you're not grandfathered in.
Yeah, exactly.
Correct. Perfect.
May I just clarify that the date is November 7th, 2014 is
Oh,
the
sorry.
the
Thank you.
in-use date, just to clarify.
And your competitors are grandfathered in.
Yes, sir.
Oh, that's not fair.
No, sir.
That's an unfair advantage, but anyway, let me just say this. That you are anticipating a rule change.
Yes.
The district, are you aware of the rule change?
We'll wait till we get a witness from the district. Let's finish with Mr. Gomez.
And the rule change would, would really allow you to continue to operate.
From my understanding, yes.
Your ships, are they any good?
I think so. I think so.
You can take a bag with you today if you'd like, sir. I have 4 bags.
No, that's
Sorry,
only.
that may create
No,
bias.
no, that's. But you're one short, there's 5 of us.
That's true. I ate one on the way. I couldn't help myself.
Okay, no more.
Thank you.
Doctor? No? Okay. Anyone else have any questions for Mr. Gomez? No. Thank you very much. You have another witness?
Mr. Furlong, only if there's technical questions.
Wait a minute. Did you have a question?
Oh,
Is there any manufacturer of chips able to comply? Is there any equipment out there, even outside of California? It's sort of a bit of a background question, and maybe it's already been answered. Any bit of equipment in America that actually could meet this NOx?
that is a very good question, and it's a similar question to what Ms. Prusak asked, and I do have a witness that can answer that question, so if I could just briefly introduce him. I have Mr. John Furlong from York Engineering. John, can you please state and spell your name for the record?
It's John Furlong, John, F as in Frank, Urlong.
And who is your employer?
York Engineering.
And are you a consultant for Anita's?
Yes, that's correct.
And you conducted a survey of burner manufacturers?
Yes.
Thank you.
You heard the question, you can answer it.
Yes. The answer to that question is there's nobody that we are aware of anywhere in the United States that is capable of manufacturing or guaranteeing a low NOx burner capable to operate in the 30 ppm range at the temperatures required for tortilla chips. And it's our understanding the district now recognizes that, which is why the rule is being changed, because they weren't able to find a feasible technology either.
Thank you.
And what you just testified to is in Exhibit B. Is that correct?
Yes, that's correct.
Other questions for Mr. Furlong? Mr. Gilchrist, did you have any questions for Mr. Furlong?
No questions.
Did I skip over you?
It's just clear to me that your competitors are smooth operators. That's all I'm going to say.
Doctor?
Can we ask questions now of the district?
When we have a witness from the district, yes. We don't at the moment. We have Mr. Furlong. Do you have any questions for him? Okay. Ms. Bird?
I just have one, just only because I just have to make sure that I'm comfortable. When you did your survey, how did you determine that there's no other equipment that's available?
Well, and that's a very good question. And typically, being that we do a lot of permitting stuff, these kind of questions are asked of us quite a bit, helping our clients find technology. So we're very familiar with all the major burner manufacturers that are out there here in the United States. It's not that big of a group of folks that do that kind of work. And then even more so, the folks that do food-specific burners, the group is pretty small. So we knew already who the top 3 to 4 burner manufacturers were. They're names that people that do permitting and engineering work recognize, like Maxon and Flynn. They're companies that have been around for 50 years or more. So they're very well known. And then we tried to shore up our analysis by also doing just a blanket, literally a literature and Google search to see who else might pop up on the radar that does food-specific burner installations and burner manufacturing. And so from that list, that's what we started with.
And then you randomly selected who you contacted? I mean, I understand that you went specifically to the food.
No, these companies all have technical sales engineers, and so that's who we start with.
Okay.
So we can kind of talk engineer to engineer, and then you sometimes it takes a little bit to find that right person in the company that you're working with, but they're familiar with emission standards, and real quickly they can find you the right person. And in some cases, we knew who the people were already from previous project work.
Okay, so the 5 that you have here in your report, how many did you contact?
All of them.
Oh, no, I mean, out of all of these other people that you mentioned, how did you?
These
This
were
is
the
only 5.
These were the 5 based on our expertise that were remotely capable of even delivering any kind of a burner product, let alone a sophisticated low NOx one.
Maybe
And there was basically nobody else even popped up. This is all that popped up on our radar when we did our initial survey. This was it.
Okay, just these 5 were all that?
Yep.
Okay, that's what I was trying.
Yeah.
It sounded like you were saying there were like hundreds and all you contacted were 5, so I just wanted to make sure.
No, there's only 5, and the 2 or 3 top players are names that the district knows very well and we know as well. So they're very reputable companies, and I think the folks at the district would agree with our survey that it was pretty extensive and we didn't overlook anybody.
Okay, thank you.
Okay. I do have a question, Mr. Furlong. Glass plants burn a tremendous amount of fuel, and we're able to comply with NOx emission limits by not using air for combustion, but rather using oxygen. In fact, that technology was first, I think, introduced in Mexico in some of the glass plants there. Are you aware of anyone doing research into the use of oxygen rather than air for burners such as this?
I am familiar with oxy burners. Gallo Wine and Gallo Glass is one of our clients, and we routinely help them do permitting and engineering work on their big glass furnaces, so it's something we are familiar with. To tell you the truth, I've never heard of anybody using that particular type of combustion technology on food products, and I just don't understand the combustion characteristics enough to know if it would work on tortilla chips or not, if they would just burst into flames, or because I think the temperature profile when you introduce oxy-fuel, it really changes the flame and the combustion a lot. I think it works good in furnaces that are melting glass, and I think they operate at like 15 to 1800 degrees F, but I think that might be too hot for tortilla chips.
Don't want to burn them.
No.
Any other questions from Mr. Furlong? Any other witnesses, Mr. Thaird?
I have no other witnesses.
Okay, Mr. Gilchrist, I think the board would like to hear from.
Yes, Mr. Chair. So I have 2 witnesses here, and I think the person who could best answer the question regarding the timing of Rule 1147's intended amendment is Wayne Barsakowski. It's my understanding that in or about June of this year, June 2017, that we're going to ask the board to amend Rule 1147 to specifically exempt food ovens from its purview. Currently, there is not language in 1147 that specifically exempts food ovens. There's other items such as charbroilers, boilers, water heaters, et cetera, that are specifically exempted from 1147, but at this time, food ovens are not exempted. And with that, I'll I'd like to ask Mr. Barsakowski to introduce himself and state and spell his name for the record.
Hello. Excuse me. Hello, my name is Wayne Barsakowski. I'm an AQ specialist in the Planning and Rules Division of the district.
Spelling of your name, sir?
Yes, my name is Wayne, W-A-Y-N-E, Barsakowski, B-A-R-C-I-K-O-W-S-K-I.
And did you take the oath, sir?
Yes, I did.
And are you involved in making rules for the district?
Yes, specifically NOx rules.
And are you involved in working on the proposals to amend Rule 1147?
Yes,
And are you familiar with the issues regarding Rule 1147 and Anita's Mexican Foods?
yes.
Is there an intended date for amending Rule 1147 currently?
Yes, it's by the June governing board meeting of this year.
With respect to food ovens, how would Rule 1147 address food ovens?
We intend to clarify that they're exempt, a little cleanup from past revisions or adoption of Rule 1153.1, so that it's clear that Anita's is no longer subject to Rule 1147 requirements.
And as part of your analysis of assessing whether Rule 1147 should be amended, have you been involved with assessing whether or not the 30 ppm limit is something that can be met by food ovens?
That's not a straightforward answer in the sense that, there are ovens that use ribbon burners, there are ovens that use air heating burners. There are different conditions in terms of temperature, and that's related to the process. Certainly, since Rule 1147 was adopted, food ovens had a longer time frame to comply because we were looking at issues specific to food ovens. So, we did result in an amendment in a rule adoption 1153.1. This is a continuation of that to allow food ovens to be treated separately from all the other processes.
And you mentioned Rule 1153.1. Does that address food ovens?
Yes.
With respect to ribbon burners, such as are used as part of Anita's food ovens, do you have an understanding of whether, though there are ovens that could meet Anita's needs and still meet the 30 ppm limit? Or would that be a better question for the permitting engineer?
Well, I think you can ask both of us, but in terms of Anita's situation, the recommendations we put forward or the scale we put forward in 1153.1 would be more appropriately than how they're regulated under 1147, in which case that would be a different emission limit.
And is that emission limit 60 ppm in 1153.1?
Not knowing the details of Anita's, that's my supposition that it would be 60.
I don't have any further questions, but I suspect that the board might either have questions for this witness and/or for the permitting engineer.
I think so. Mr. Thayer, questions from Mr. Barsakowski?
Yeah, just a couple of clarifying questions. Is there a plan by the district or an intent by the district to amend 1153.1?
Yes.
Is that on roughly the same schedule as the 1147?
No, it would be later.
Okay. If 1147 is amended to exclude food ovens, at that point, would there be any rule-related reason? I understand the permit would still need to be reviewed, but is there any rule-related reason not to give a permit? In other words, once food ovens are specifically exempted, is the path clear for Anita's to obtain a permit for line number 4, or does it also need to have 1153.1 amended?
I can't speak to other rule requirements, but 1147 amendment would take care of that issue. As of now, they wouldn't be, well, once they're amended, that rule is amended, they would not be subject to 1153.1 at that time. They would be subject to, NSR requirements.
Okay, thank you very much. The reason for my question is really also for the board. I don't want, we're seeking to October 31, 2017, but if the district is going to take, it would end up taking the position that 1153.1 would also need to be amended, then we might be back here in 5 months again, asking for 3-4 more months to let that rule be amended also. So that's why I'm asking the question, is October 31, 2017 enough, or should we, just in case, seek another few months to allow 1153.1 to be amended? That's the reason for my question.
Well, once they're not subject to 1147, at this time, the way the rule is written, 1153.1, they would not be subject to that rule.
To 1147?
To 1153.1 and 1147.
Okay,
Both
and they
of
could get a permit just based on the permit review?
Whatever requirements, the other requirements, which you'd have to talk to.
Okay. And I can let them talk separately about that. We don't need to include the board in that discussion. But thank you very much.
Board members, Doctor?
Just for background, why was this rule created and incorporated in a situation where the board, the district already knew that they're going to have a problem with the NOx emissions for this category of, in other words, why was this category included? Because you must have known that these people were going to be higher.
We didn't know that.
You didn't?
There's a history since the late 1990s of permit conditions, permits that were granted to food ovens and many other types of equipment, which had a range, 30 to 60 ppm. And when 1147 was adopted, and it's a bit of the kitchen sink rule for NOx, it was meant to get everything else that hadn't been regulated previously and bring it to approximately 2005 backed. That was the goal set by the governing board in the SCAQMD. And we recognized that there was some uncertainty here. We provided more time. We did a separate rule for these ovens. Unfortunately, the timing for Anita's didn't quite work out. And we had a little bit of cleanup on 1147 that had to be done, and unfortunately things got delayed and we haven't been able to get to it till now.
Thank you.
Any other questions for Mr. Barsikowski? Senator?
Right. 1147 was adopted when?
Original adoption was in 2008.
2008. At the time it was under consideration for adoption, did any of these manufacturers come before the board that you know of to express their concerns about the adoption of this rule at that time?
At the 2008 adoption, no, but we did an amendment in 2011, and some manufacturers of food products did give testimony at workshops and meetings.
What was the amendment?
I'm sorry?
What was the amendment?
The
in
amendment,
2011?
the amendment was, did a number of things. It removed a requirement for time or gas meters. It provided additional time for people to comply. It delayed the schedule. And a few other little small things, clarifications.
What's the definition of compliance at that point in time, 2011?
I'm sorry, what?
What's the definition of compliance in 2011, which was different from 2008?
For these types of ovens, for both the adoption and the amendment, people could install ovens without having to meet the compliance limit to a much later date than many of the other equipment. If they would install their oven back at that time frame, 2012 roughly, they wouldn't have had any requirements for 15 years. But that grandfathering in of these equipment did end. And so between that timing and the timing of 1153.1, Anita's was, just in the wrong situation.
So Anita's did not install their ovens in a timely fashion, is that what you're saying?
They didn't start the installation, and at a time where they had the opportunity to take advantage of being grandfathered in.
Had an opportunity?
Yeah, they missed an opportunity to be able to take advantage of that.
Did the Anitas ever explain to you or to anyone that you know of why they missed the opportunity to comply at that time, since they were in business?
Anita's was not involved in the 2008 and 2011 amendments 1147. However, they did have some representation at the adoption of for the rule development for 1153.1. And I can't speak of Anita's staff, but certainly their consultants were told that, what the form of the rule would take, and that, if they had their equipment and their permit applications in by a certain date, that, they would be covered under that rule at that time.
I see. So if Anita's had installed or made the application to install the ovens at the time that the application would be made to meet that deadline, they would have been okay. Is that what you're saying?
Yes, yes.
Can I address a point on that? I was speaking to Mr. Gomez. Businesses have different cycles. The business was not in a position to expand and have new lines in 2011, 2012. They've only grown a lot in the last year or two. So there was no way, and Mr. Gomez can talk about this if you'd like, but it's not a situation of they were just late. It was they didn't, you got to get bank loans and money and expand in a new building. And, it wasn't so much that they snoozed and they just, decided, well, we're just not going to try to comply with something.
Was line 4 in operation at the time, or did it come after the fact?
It was after the fact. It was after all this happened. So as you pointed out earlier, it was not grandfathered in by, 5 years ago, they were just not in a position to expand and build new lines.
It was a small company.
Yes, exactly. They've expanded a lot over the last couple of years.
On the rule change, 1147 amendment that's being proposed at this time, correct? Do I understand that?
Yes.
To exempt ovens.
To exempt these, all food ovens, including theirs.
All.
It's a clarification.
For what purpose was it created, the Rule 1147? There must have been a problem. That's why they came up with Rule 1147.
Well, 1147 addresses many other kinds of ovens that are not food ovens, and furnaces and dryers, many other processes. There are over 6,000 pieces of equipment regulated by this rule. Food ovens are a few hundred.
Okay. So we need 1147 for other reasons?
Yes.
Okay, fine. So you're just going to exempt food ovens?
We're doing other amendments, but that's one of the amendments and the clarifications that we need to take.
What are the other amendments?
We're going to provide some additional delay, provide additional options for how to for small sources to comply, and some other cleanup of clarification of some exemptions that have caused problems for folks other than Anita's.
So it's a catch-all.
Definitely, yes.
You're lucky.
Ms. Brissette?
I just had one question, and that is, would you have any opinion regarding the conclusion that is reached in Exhibit B, that there are no existing burner technology for this particular application that can be guaranteed to reach 30 ppm NOx?
In the position that I'm in, I can't say based on the information that's, available to the general public one way or the other. I have to work on data, and we will be collecting additional data over this next year regarding food ovens. But I can tell you that in Anita's situation, it does run, it's a type of oven where in the past, the permits have been higher than 30 ppm, say around 60. That's typically what these devices have been permitted at. And that includes facilities that are both inside and outside of reclaim. Those sort of limits are written into permits as opposed to 30 for this type of process.
There must be some reason why district staff has determined that it is seeking an amendment that would exempt the food ovens such as those used by Anita's, and am I assuming correctly that it's based on the fact that the district's own review shows that it's not feasible at this time?
Well, the revision to 1147 to food ovens is not specific to what emission limit. It's a cleanup of what we did when we pulled food ovens into their own category, and unfortunately we weren't able to get to that sooner. Whatever the permit limit is, we would still do that revision, that amendment to take them out of 1147 so they could be treated in a different, as a separate category of equipment.
Okay, so that will be coming down the pike later.
Yeah,
Okay.
we're hopefully by the end of the year.
Okay, and I said I had one question, but I actually have one more, and that is, to your knowledge, and if you know, that's great, and if not, you can say you don't know. Do you know of any other manufacturer or facility that has a similar oven making similar products that is able to meet the 30 ppm? And I understand many of them might be grandfathered out, but are you aware of any that are meeting it?
I'm not aware of any at this time that meet that limit for this type of process.
Thank you.
Doctor?
This is a very naive question from a very naive doctor about this, but you had, somebody had on the board here, I think it was Mr. Camarena, raised a question about NOx usage. I mean, not NOx, I mean oxygen. And the question I have is, there have been some references in other cases that have been before us about a 3%, certain things being met at a 3% oxygen. When you look at oxygen, do you guys do a dose response curve so that this works or doesn't work at a low level, and then as you go up, you may reach an optimum level? If you go higher, what you have is a burned chip. I'm just curious about that. The other question, okay, that's it. That's my question. Thank you.
Well, in terms of the food production, from my discussions with not Anita's but other manufacturers, these processes are fairly well guarded. Trade secrets in terms of how they produce their product, the look, the texture, all those components are are addressed by each company. And in terms of, as in any burner, there's a trade-off in terms of primary combustion air mixing with the fuel and that ratio, how it affects emissions. So they're always undoubtedly balancing efficiency and quality of product. But other than that, I can't speak to anything specific about this process.
Thank you.
Senator?
I can't help but note the fact that the district selected a pretty qualified person to today respond to the questions without any mental hesitation or reservation, and knowing the subject matter as well as you do. I think I heard you testify, however, that the last major amendment was 2011?
Of 1147, yes.
2011. And now my next question is to the respondent, Mr. Chairman and members.
Did you have any more questions for Mr.
No, I do not.
Okay. So,
This order of abatement was entered in 2015, which was after the last major amendment to 1147. When did you buy your oven?
I don't know when the exact purchase order was made, but if I'm not mistaken, it was 2013.
I'm sorry, say it again?
I don't know when the exact purchase order was put in, but if I'm not mistaken, it was 2013.
2013. Did you know, was it known to your company at the time of the purchase of the oven that you would be out of compliance with this rule, 1147?
I can't speak to that. I wasn't part of that decision.
Maybe your expert can.
I was not involved in that decision-making process, but I believe what happened is when they were purchasing the equipment, they would have complied with 1153.1, the grandfathered rule, which would have exempted them out of 1147. That was the timing that they were hoping to achieve. However, due to contracting delays and purchase order delays and just making sure the business could float the millions of dollars it was going to take to buy this equipment, the timing didn't work out well to meet that grandfather date in 1153.1, because that would have been their saving grace. It just didn't happen quickly enough. So the equipment was purchased way before 1153.1 due dates, and the intent was they were hopeful they could make that.
1153.1 gave you a grandfather date, November 7th, 2014.
That is correct.
Then when did they put the order in for their equipment?
I think more than a year before that. But like I say,
You don't know that to be a fact.
No, I was not involved in that purchase decision. But my recollection serves me, it was well before that date, sir.
I think it's also important to, in terms of, Anita's has had 3 hearings, spent a lot of money on me and consultants to get this done. That is not, they would much rather have gotten a permit 2 years ago or gotten grandfathered in. We would not have had 3-4 hearings. So I think your question is good questions, but I think it's important to keep in mind that there is no reason for Anita's to want to be here subject to the board constantly providing extensions. All Anita's wants at this point is a permit. That's all they've ever wanted. And it's just they found themselves in an unfortunate position.
Well, it was untimely.
Yes, and if I may add, sir, Anita's would love to buy a 30 ppm burner if there was one available. It would save them not only that, all the complications with an abatement order, but it would lower their facility NOx cap and allow them more room for growth. So there is an incentive for Anita's to find a lower NOx burner, which is simply not available.
Let the buyer beware. And it seems to me, at least, and I don't want to draw any conclusion, that the competitor was doing very well under this exemption. And it was probably a bad guess on the part of Anita's that they could buy this oven and be competitive and still be under that 1153.1, and as you stated, which is not the case, as we now know.
And interestingly, if any of those competitors were to install a new line in the past year, they would be in the exact same predicament as Anita's right now.
If they were to have done that.
If they were to expand, yeah,
If they were to expand.
that's correct.
Yeah, okay, I just think you missed the boat. Go ahead.
Okay, Mr. Gilchrist, well, let me ask the board. You need to hear from the engineer? Nope. Okay.
Thank you, Mr. Chair.
Okay, I'll ask, oh, we have a couple of, before I ask for closing statements, we have a couple of members of the public who would like to address the board. The first one is Maricela Garcia, followed by Alan Lee. You each have 3 minutes, and unfortunately, the timer isn't working, so I'll hold up one finger when you have 1 minute left. Take the podium there, and before you start, I'll ask you to state your name, spell it, and then tell us whether or not you took the oath. Okay? Yeah.
Thank you. My name is Maricela Garcia, Maricela I'm a quality control in Anita's.
And you took the oath?
Yes, I did.
Okay, you have 3 minutes.
I'm a quality control in Anita's. I'm here in behalf of my coworkers to speak for them. Anita's has gave us an opportunity to provide for our families. Some of us are single parents. We only work in Anita's, and we have kids to provide for. In me, I was a single parent living at my mother's house, didn't have no income, never had a job, and Anita's gave me the opportunity to start, learn, and I've gone from packer to operator to quality control now, and I've been out of my parents' house, living well with my 2 kids. So they've helped me a lot, especially with like not knowing how to even pack or anything to do anything. They taught me how to learn how to work in machines, chemicals, and stuff like that. So I thank them for that. And depending on your decision today, it depends on so many people's economic right now. Like, we could lose our jobs, because that would be like a lot of people without jobs, and it's hard right now to find a job, actually, and to be stable. But thank you for hearing me.
Thank you. Mr. Gilchrist, any questions for the witness?
No, Mr. Chair.
Mr. Thayer?
No, thank you.
Board members, doctor?
Yes, I think you articulated your position very well. How long have you been there?
Almost 6 years.
Good, wonderful. Good, thank you.
Any other questions?
Yeah.
Senator?
To your knowledge, when did this line 4 come in, this number 4, the one that's in question? When was that installed, and did you work on it?
I was a packer when they started installing. I'm not sure about around the time, but we saw it build up. So.
You were a smaller outfit, now you're a bigger outfit.
Yeah.
Oh, good. All right.
Thank you. Any other questions? Thank you very much.
Thank you.
Mr. Alan Lee.
Okay. Yes, my name is Alan Lee. My name spelled A-L-L-E-N-L-E-E. And yes, I took the oath.
Thank you.
Yeah, I've been working at Anita's for about 4 years. I'm a maintenance mechanic, so I work on line 4. So whenever there's a problem with line 4, I'm the one that they call. And basically, from my point of view, Anita's is probably the only family-run organization that really cares about the people that actually work there. On line 4 alone, you have at least 33 people that work on that line. And when we say 33 people, we actually mean 33 families. And then you're talking about 270 people that actually work for the company, so that's 270 families that are involved in the company. So whenever you're talking about line 4 and you're talking about Anita's, you're actually talking about a lot of families that are affected by, a decision of not running line 4. And from my personal experience, last year I lost my son. He was 23 years old. He was in a car accident, and when it was time for the funeral, Anita's was there for me. They helped me pay for the funeral, and one of the people from our management came to the funeral with me. So when I say Anita's is like family, when I needed them, they were there. And that's what I mean. Anita's is a family. We're a family company. And if you were to make a decision on letting line 4 go, it would hurt so many families that depend on Anita's. And I say depend on them. Mostly, I mean, Anita's is, we have different, Hispanic, black, white, but it's mostly women, single women that work there. You're talking about maybe 85, 90% women who are just working there trying to make and provide for their family. So as far as I'm concerned, Anita's is my family, and they adopted me, and I'm there as long as they need me.
Thank you. Mr. Gilchrist?
Just wanted to say sorry for your loss, and no questions. Thank you for your testimony.
I appreciate that.
I have no questions. Thank you, Alan.
I also want to echo this board's condolences. I think loss of a child is probably the worst thing that can happen. Ms. Prusek?
Yes, I am very sorry for your loss. I also wanted to thank you for extremely relevant testimony regarding the actual people who work on the line. Thank you very much.
Mr. Senator?
Yeah, we all certain empathy and sympathy for your loss. That's a car accident. They leave home in the morning or at night, and they don't come back. That's tragic. You're strong, hang in there. But one question. Do you know of more than one person work for the company that's in the same family, like two sisters, a mother and a daughter?
There's probably, in that company, there are, unlike a lot of other companies, because I've worked at other companies, they actually allow family members to work together. A lot of companies, rule against that because of conflicts of, of schedule and other things like that. But there are, speaking of family members, she has 2 sisters that work at Anita's, and there's a lot of situations. Actually, my wife used to previously work at Anita's, so we're definitely a family company.
So we're talking about one household with 3 employees, not a household per employee.
No, not a household per employee, not in every situation, but there are situations where there are, more than one person that works in that family, which it would probably be devastating even more so if they were to lose their job, because then there would be 2 incomes that would actually be lost.
That's a point well taken and well expressed as opposed to the other. Thank you.
Thank you very much.
Thank you.
Any other member of the public wishing to testify? There are none. Mr. Gilchrist, you may make a closing statement.
Just to be brief, the parties have stipulated to the proposed order, and I would just ask that the board review it. If they have any questions or would like to discuss, obviously we're available, and with that, I'll submit.
Mr. Third?
Yeah, I'll submit on the findings and decision as agreed to with the district. I also want to thank the district very much. I know that this has been a long time. I mean, this has been a couple of years, and the district has been willing to cooperate and recognize Anita's situation. And so we really appreciate that, and we thank you for stipulating to certain facts today.
Thank you. Okay. Ball's in our court, board members. I think if you all look at Exhibit B, it clearly sets forth the effort that was made to find equipment that would do the job, that would produce the product quality that Anita requires in order to satisfy its customers. And the Exhibit B, which is the review of the technology by York Engineering, coincides with the what we've heard from the district, and that is that at this point in history, there is no equipment that will satisfy the 1147 limit of 30 ppm. And as a result, the district is proposing, the district staff, rather, is proposing to the governing board the adoption of amendments to Rule 1147, which are expected to come before the governing board in June of this year. And if adopted as proposed, that would fold in Anita's Mexican Food Corporation into the exemption, and would at that point then be in compliance. And for those reasons, I believe that there's good cause to adopt the proposed findings and decision set forth in Exhibit 1. Ms. Broussette?
I agree that I can find good cause, and my hesitations always are when there's an order for abatement that goes on a long time, for many years, and also, and this one would go for over 2 years with the modifications. And the other hesitation I usually have is one where it may resemble a variance. I can find that it's not, well, I can find number one, that there is good cause to extend as long as this will extend. And the reasons, as you've stated, Chairman, is that the evidence is clear to me that there is no existing technology at this time. No one is using it in the district. That was confirmed by Mr. Barsakowski, and I echo, thank you for your extremely knowledgeable testimony off the top of your head. And the second part, I think that Anita's has really gone the extra step that we've asked them to take in the past to make sure that they are moving towards compliance as opposed to just hanging out waiting for something to happen. And that is to do what is in Exhibit B and to really make sure that there is no technology out there that that currently exists that would take care of this issue, and obviously work diligently with the district to try and move towards this amendment. And I'm satisfied that the amendment, anything could happen at the governing board level, things slip. However, I'm satisfied that as currently drafted, the oven or the line issue would be exempted. And I think that's enough for me to find good cause. And this is the difference between this and a variance. I'm not as concerned. I think that the I think that there was evidence to show that there were attempts made by Anita's to try and get within that safe harbor. It just didn't happen, but that's the reason why we're at an order for abatement today and not a variance. So with all of that, I can find good cause.
I would also point out that Anita's has every incentive to reduce its emissions in order to get as far below its cap as possible to provide a cushion for possible future expansion. Anyone else? Ms. Byrd?
I agree. I think we can find good cause to extend this order, as well as, well, one of the areas that has been added to the conditions, which gives me at least another level of comfort knowing that Anita's is making serious effort, is that they will be hiring a consultant during the period of the order just to follow up on the scope of the work that's in front of them, and that gives me an additional level of comfort, and I think we can make the finding.
Any other comments? Senator?
For the record, I would suggest that the rule that's being amended should include language that would state that 1147 as amended, proposed, subsequently amended, would apply until equipment is available to meet the requirements set forth in 1147 as it is today, and give a certain time period for which those who are not in business to comply with that by acquiring additional equipment that meets the guidelines. It's for a reason that they put it in, so maybe 10 years, maybe 15 years, but give them some incentive. And when the board adopts the amendment, they can specify in that amendment that this reduction in requirements, or the amended version of 1147, exists until. The until is when the equipment is, ovens are available to meet the guidelines that's set forth in the current 1147, and a certain amount of time would be given to businesses to comply. And it should not be unreasonably tight. That's what I think. Number one. And number two, is there a fee associated with this?
This is an order for abatement.
No fee, all right.
Senator, what you've described is the process that the district has to, on a continuing basis, watch technology as it unfolds and propose amendments to existing rules and propose new rules as the technology is available. And as I mentioned, the company does have an incentive, even now, to further reduce its emissions, so I think we're in good shape. Ms. Brissett?
Yeah, and I just wanted to add, I think that's a very good statement and point, but I think Mr. Barsakowski stated that they're not just, the district is not just exempting food ovens, but rather exempting them from 1147 in order to, down the road, adopt a separate rule that would apply, I don't know if just to them, but certainly to fewer ovens and equipment than is currently in the catch-all of 1147. So I think that's a good point, and I think it is being covered. And I just wanted to say one other thing, and that is I said after Mr. Lee testified that I thanked him for his very relevant testimony, and I think when it comes to good cause, I think it's important that we factor in the fact that if we did not extend today knowing that the district is going to or has every intention of exempting this food line, then the consequences would be severe for a large number of people and family I believe it's 26 who work on line 4, and I think that really factors into my good cause, because there is no good cause not to extend it, knowing it's going to happen anyway, but these devastating impacts will occur if we don't.
Any further comment? Okay, in the matter of South Coast Air Quality Management District petitioner versus Anita's Mexican Foods Corp., case 6017-2, I move that we adopt the proposed findings and decision of the hearing board set forth in Exhibit 1 with one change. Mr. Thaird and Mr. Gilchrist, on page 3, lines 14 and 15, they refer to Rule 1147 and Rule 1153.1 as currently drafted. The word drafted kind of suggests that it's not in effect, but I think you mean that is in effect. Okay, so is it okay by you all to change the word drafted to in effect, so it reads as currently in effect?
Yes, Mr. Chair.
Mr.
Yes,
Thaird?
so stipulated.
Okay. So with that change, that will be my motion to adopt the proposed findings set forth in Exhibit 1. On page 1, we delete the word proposed in the caption and in the title of the first paragraph, and then also in the succeeding pages down at the bottom in the footer. And that completes my motion. Is there a second? Ms. Byrd?
Second.
Ms. Byrd has seconded the motion. Discussion on the motion. Dr. Lerner, how do you vote?
In favor.
Ms. Prussack?
Yes.
Senator?
Holden, aye.
Motion passes 5-0. I did want to make a comment. Neither the district nor the hearing board intends to harm business, but they do intend to continue pushing for clean air. And on a continuing basis, looks at rules and regulations, looks at technology to see what is available. And these past couple of years have been spent in apparently examining what is available for the food industry. And conclusion was that at this point and in the foreseeable future, the technology does not exist to further reduce emissions. I also want to comment about what appears to be the management style at Anita's Mexican Foods that results in us hearing, not only today, but at the last hearing, some good comments about how the employees are treated. Anyone else?
Yeah.
Okay.
Very good points made, Mr. Chairman. My point of view is that the district should not relax standards that's already set forth. And there was for a specific reason why the district did that, but relax only under extreme circumstances, where an extreme hardship is being imposed, period.
If there's no other comment, any other business?
Yeah, I just want to make, I am really impressed personally, being in the humanity business, trying to keep people with humanity healthy. I'm impressed with the company's attitude towards its employees. I think it's really unique in this world of, you know, what's happening out there. The other thing is, now that I've said that, may I have a chip?
There's no other business. We are adjourned.